Also, again, I liked what Advocate Batohi said when he spoke about the culture and ethical leadership. And this brings me to my last set of questions, because I agree with you 100% that the leadership always sets the tone of a culture in a particular environment. That is why you'd find that one employee employed by company A could behave in a particular manner, and if that person is employed by company B, their behavior totally changes. We have experienced it as professionals in different areas. You find that one person is employed by government, they come in late, what. Immediately they're employed by a private company, they change totally. So the problem is not the person, it's the culture, it's the environment that cultivates the kind of a laissez-faire attitude or the kind of a hardworking and disciplined person. So when you speak about leadership, we take serious that statement, Advocate Batohi. And we believe that the leadership in the country then must set the tone of ethical leadership and leadership that is able to be accountable to the people. And these are the following questions I want to ask in that regard. The decision by the National Prosecuting Authority not to prosecute President Ramaphosa, in light of the findings of the Section 89 independent panel, obviously has left South Africans with quite a number of questions. And the public does deserve some explanation around these matters. So we're sitting with you today, and the entire millions of people are sitting with you today, and we'd like to have an understanding around the following matters. In relation to undeclared foreign currency, how did the NPA handle the issue of foreign currency that was not declared? And this is in the context that the South African law requires the declaration of foreign currency above a certain threshold to the South African Reserve Bank. The public must understand the rationale of not prosecuting this apparent breach of financial regulations. That's number one. Number two, the South African Reserve Bank stated that the transaction involving the foreign currency was not perfected. Effectively meaning that no legal transaction took place. Why then was this not considered as money laundering? The context of the question, the chair said we must start with the question and come to the context. The context in this particular question is that in incidences of money laundering, it will involve dealing with funds derived from illegal activities or obscuring their origins. If no legal transaction occurred, the possession and handling of the foreign currency may meet the criteria for an investigation under anti-money laundering status. The third question is, why did the NPA choose not to act on Section 89 independent panel's findings that Mr. Ramaphosa had violated Section 34(1) of the Prevention of Combating of Corruption Activities Act? And the context thereof is that this particular section referred to here obliged certain individuals, including those in positions of authority, to report corrupt activities involving amounts above 100,000. Was this obligation fulfilled? If not, why was it not prosecuted? The second last question relates to the accountability of the president as a sole member of the close cooperation of the firm. And the question goes, Mr. Ramaphosa, as a sole member of the CC of the Palapala farm, how did the NPA reconcile this fact against accountability for the action and irregularities tied to the farm, not now to him, but to the farm operations? As the sole member of the CC, he bears ultimate responsibility for its compliance with the law, including handling of its finances and reporting any irregular activity. The last question is, why has the NPA not found it unlawful for an individual to possess such a substantial amount of undeclared foreign currency? The possession of these large amounts, and I think we indicated earlier, without proper declaration, raises concerns about compliance and exchange control regulations and anti-corruption laws. Why was this not pursued as a prosecutable offense? And these questions, again, I want to contextualize them. The issue is the leadership tone. The issue is the leadership presenting itself as accountable leadership and as well as ethical leadership, which sets then the tone for the entire government sphere. And I understand that at some point you said there's a strategic direction to arrest people at lower levels. Obviously, you said with an intention or with the hope that they are going to, there's going to be a link of evidence to people in higher authorities. But those in higher authorities of government must be the first ones to exemplify what ethical and moral leadership. And with your suggestion that there must be an amendment to how the appointments to the NPA are done. And you say that it is in order to ensure that we deal with the financial and operational independence of the NPA. And on the same breath, you've mentioned that neither the president nor the previous ministers have interfered with your work. So the question then is, as a last question, Chair, if the president and the ministers, or the president who appoints the three levels at the NPA, does not interfere or has not interfered, why do we need to make amendment to ensure financial and operational independence? Why is there a need to do that if there is no interference? If right now the NPA enjoys total independence with that provision being there, why do we need to then make amendments to it? Unless if obviously we're saying that there is some level of limitation of that independence as a result of that. Or if we want to then derive the lack of independence to individual interferences, at whatever point we want to make an assumption of, then we must deal with the issue of ethical character of leadership that we are able to place in positions of authority. But it does not then necessitate that we must change legislation. You know, that is the last question, Chair, and thank you so much.
Thank you very much. I just wanted to, and Honorable Gupega, just indulge me with 1 minute. So I understand there are people with planes to catch. So I just want to say to the committee, we are going to take all the questions, deal with the answers, and then be done for the day, if that is okay. I've already begged for indulgence, at least from some teams have split, others staying and others leaving. I don't want the committee room to be empty of people when members are still on the floor. So over to you, Honorable Kupe.
Thank you, Chair, and greetings to the teams gracing us with their presence today. I would like to piggyback on what my colleague just spoke about now, because I think what he just said and what I've got here is more interrelated. Even though bulk of the questions have been asked, I think the first question would be to all three departments or entities that are visiting us today. On the Zondo Commission, over 1 billion rand was spent. And given the lack of prosecution, does the SIU, the DPCI, and the NPA believe that this was money well spent? And this is speaking now to the over 1 billion rand of the Zondo Commission. Was this money well spent or not? That's the first question. And the second one is, according to the same three entities as well, what do you guys think is the media's role in this so-called State Capture Commission, given the prominence in society of the commission, because this thing is being aired and flighted all over, versus the outputs of the commission, and versus the fact that 0.01% of the work done by, for instance, the NPA relates to state capture? And what is basically the role of media, according to the various teams, to all three spheres? What do you think is the role of the media here? Are the media pushing a certain narrative? What do you think? What is your position or posture on that one? And then I think, moving on, to the NDPP. The NDPP is appointed by the president. And again, piggybacking on what my colleague spoke about earlier, can the NDPP be trusted to be entirely fair and impartial when it comes to issues involving specifically the president now? Can the NDPP speak to that? Given, and I ask this given what happened to the previous public protector that we had. When she went and she asked a couple of questions, she sent them to the president, and I think we all know what happened after that. Can the NDPP indulge us on that one? That can she be trusted to be entirely fair and impartial when it comes to issues involving the president? That's the one question. And then the next one is, the NPA has a duty to carry out its functions without fear, favor, or prejudice. This means that impartiality is critical for the NPA. However, there have been several concerns and discussions on the impartiality of the NPA and the potential conflicts of interest that may arise considering the private donor funding model. Now, given the private donor funding model and that there is funding that comes from the private sector, what is the impact on the investigations that is there, given that they now have people who are funding them? Can they still continue to be impartial? And please, when you indulge us on that one, please note that we've heard that the argument that the NPA does not receive donor funds directly and that they are channeled through the National Treasury. Let's understand that that argument is weak. Please don't go to that one, because I say that the argument is weak because it falls flat until we are given the names, or there's a listing of the names of the entities and or the people who are the private donors is made available to the public. Can the NPA speak to and comment about this? And then thirdly, the NDPP has made representations to the State Security Agency to vouch for the NDPP's deputy. And after he was denied, and this was after he was denied top security clearance in October 2024. This was now, he was denied the security clearance chair because the deputy NDPP holds dual South African and British nationality. So basically he's a citizen in both countries. And I think for this reason, he was denied clearance, as this poses a risk of foreign influence over prosecuting decisions within the Republic. I think with that being said, we need to understand that when we as citizens know this, what are we supposed to think, what are we supposed to see, what are we supposed to understand about having someone at that high level in government holding a dual citizenship? I think that's a problem. I would like another comment by the NDPP on that one. And then the next question is, what happens when a proclamation is received? And I think this is for the SIU and the DPCI. What happens when a proclamation is received on an issue? And then while investigating that issue, there are more issues that arise from that investigation. Is the investigating team allowed to expand the scope? Are they allowed to change the terms of reference and investigate all of the issues that they are finding, that they are now finding there that were not on the original scope? Or is it a situation where the investigating team must let sleeping dogs lie, given that whatever issues that have arisen do not fall in that scope? I think then onto the slides from the DPCI. I think congratulations needs to go to the teams that are investigating here. ESCOM, ABB is being investigated, and IDEC and AFU recovered 2.55 billion rands from ABB. That must be commended. The question there is ABB still doing any work with ESCOM currently? And if so, what is the value of those contracts, and why would they be still working with ESCOM? On slide 22, top municipalities. This is slide 22 on the SIU to NPA slides. The top municipalities, SIU referrals, municipalities. We've got a lot of municipalities here, but I don't see our major metropolitans. Durban, Tshwane, Johannesburg, and Cape Town are not there. What does this mean? That's the question. Does it mean that there's no corruption in these cities? And then challenges, on the slide that says challenges for the SCCU. The lack of cooperation by state entities and departments. The question this is specifically to the SIU. Does this not need Parliament to give SIU more prosecutorial powers? And then slide 50, again, SIU to NPA. There's a company, SAP, Systems Applications Products, that works for Transnet. Their recoveries relating to corrupt contracts to the value of 1.08 billion was recovered from SAP. The question there is, does SAP do any work for government or any government entity or department? And if so, why is that? And is SAP blacklisted? On to slide 50, SIU NPA, Transnet Regiment's Capital. AFU obtained a restraint order in the amount of 1.658 billion, and a confiscation order will be sought after the conviction. Another question, is the regiment's capital blacklisted from working with government? And is the regiment's capital currently doing any work for government and its entities? That's a question there. Slide 26, SIU NPA, reasons for, slide 26, it says reasons for decisions not to prosecute. And I think 81% of these were insufficient evidence. I think this now speaks to our issues that we have when it comes to finalizing these prosecutions, and these prosecutions taking 10 years to prosecute. There will be this issue if we don't conclude and we as this House do not find ways to speed up the prosecution. Because, and I think one of my colleagues earlier on said, we need to give the SIU prosecutorial powers so that they don't have to hand over investigations to be reinvestigated for another 2-3 years to the NPA or the DPCI. If 81% of that says insufficient evidence, I think we need to look at that, and I'm not sure who would speak to that between the three entities. And then just lastly, Chair, slide 43, ESCOM matters. We've got Tageta, Optimum Colliery, and Templar. The AFU secured 2 settlements to the value of 480 million, and to date, 90 million was recovered. The question here is, have these owners of these companies been sanctioned? And have these companies been blacklisted? And are any of these companies doing work with the government? I think, Chair. Okay, wait, no, just there's another one. I didn't write the slide number here, but it was cases under investigation for rural development and land reform. Cases under investigation, there are 0. I'm not sure I understand that. Are we saying that the department, the rural development and land reform is clean, there's no issues there? Transnet, 995 million. I think we've seen Transnet coming to present to us here. This issue is worrying. Can someone speak to that? Why we're saying there's a 995 million rand only at Transnet, that's an issue? Or that is the cases under investigation specifically. Denel, 44 million. Cocta, 0. Prasa, just 1 case. SASA, 550,000. Can we speak to that? Are those the only cases that stem out or that come from these entities? Thank you.
All right. Thank you very much. So that would conclude the questions. So if we can go through the answers, and once again, I encourage you to get to the nub of the question and deal with it. There are some questions, Honorable Kupega, that we had asked about some of these entities, and we got extensive written submissions. So if you have not seen, I will gladly furnish those to you. But let's try and wrap up. So let's start with you, Advocate Batoibil. I think most of the questions were for you.
Yes, thank you,
Thank
Chair.
you.
There's quite a few questions. I think on the issue, the first issue that Honourable Blosi raised about the SIU legislative powers to criminally investigate, I think that is a matter for Parliament to decide. But of course, we as those that are working this sphere can of course advise. And in my view, I think any capacity or capability to investigate complex corruption in South Africa is critical. And I think we may perhaps be, I know, the comments have been made that, excuse me, if it's in one space, it might be quicker. But I think when one understands the difference between meeting the civil standard and meeting the criminal standard, one might find that even if you do grant criminal investigative powers to the SIU, it might not necessarily shorten the period because their work will necessarily mean a lot more than they currently do. Excuse me. But I think that General Labia can speak more about that aspect and what happens after the referrals are sent from us to the SIU. My colleagues will deal with the cyber skills issues. There's no capacity for intelligence in the NPA. Honorable Skosana, on the small percentage that the NPA deals with state capture-related cases, I want to emphasize again, it's a small percentage, but you're absolutely right. It's one that's in the, very high profile, and we have been, a lot of our resources and efforts has been because, notwithstanding the fact that the prosecutors deal with 800,000 to 900,000 cases a year, the end of the day, the country will consider the NPA to be a failure or a success, depending on how these cases are dealt with. That means that we give it the necessary state capture, and I'm going to make sure that but the devastating impact that it had on our country, particularly the poor and the vulnerable, particularly, the development prospects. I think we have a duty to South Africans to make sure, as law enforcement, that we hold those accountable for that. It cannot be that you bring a country to its knees and then nobody is held accountable and we don't recover the money. So it is because of the Zondo Commission, it is in the public space. So even though it's a small fracture, it's a top priority for the NPA, and it always has been for those reasons. In terms of, and maybe just the other question on Zondo Commission, I think it was Advocate Kubeka who mentioned it. Was it money well spent? I think when one looks at it, it helped to lay bare the devastating effects of state capture. And it has certainly given law enforcement a guide in terms of what this beast was about. But it didn't give law enforcement I'm sorry, can I have some water? It didn't give law enforcement a blueprint for prosecutions. Excuse me. So I think in that sense, it was a lot of money, and I certainly wish we in law enforcement could get that amount of money to ensure that there's now the recommendations of the Zondo Commission are taken forward and that we can move faster with these cases. In terms of the complexity of these investigations, I'll leave it to my colleagues to deal with. But let me just make this clear, that if one compares South Africa with other very well-resourced jurisdictions like the Serious Fraud Office in the UK, which investigates these types of complex commercial crimes, corruption, it takes them, we're not very far behind in terms of the time that it takes to investigate these matters, as well as the numbers of cases that they deal with per year, and with a much bigger budget. So I just want to bring that to your notice, because it's not just South Africa. We're struggling, and when you come to think of what the history, it is, we actually, in that sense, when you compare us with other similar institutions internationally, the figures are not that different. So these matters take a long time in order to get them trial ready. In terms of the prioritization model, I'll allow my colleagues to deal with that. But just in a nutshell, I think it was Honorable Madlala who dealt with this, who raised this. In a nutshell, it deals with all of those issues that you mentioned. It's not just one. We have a prioritization guideline, and it deals with various criteria that are taken into consideration when these matters are prioritized between the DPCI and ourselves, and all of various criteria that you mentioned. Many of them are all there, and it's about weighting the different ones. But that's how we are guided. In terms of the media versus public interest, let me say that we have respect for investigative journalists that have actually assisted in looking into trying to lay bare some of the what happened during not just state capture, but in many other aspects. But we're not driven by the media. We certainly do not prosecute because something is in the media space. And we certainly, the media puts a lot of, inverted commas, pressure on law enforcement and the NPA. We can't succumb to that pressure, because if we do, we will make mistakes. So we must have our own prioritization, and we will proceed when a case is ready. And that is why maybe perhaps some say we're not moving quickly enough. If we were driven by those kinds of pressures, maybe you'd see a lot more of these cases. So we make sure we reach the standard, and that's when we will enroll a case. With regard to the NDPP's appointment, I think given the past, that what we've seen in South Africa, you raise a very valid question, is that the president appoints a national director. Can one expect a national director to be impartial in respect of the president? Let me make this clear. That was not the case in the past. And currently now, it doesn't matter whether it's from the president, ministers, parliamentarians. We follow the evidence. And if the evidence is there, there must be consequences. The matter was raised also about the case against the president. I mentioned earlier the way decisions are taken in the NPA, and that the DPPs in the divisions take the decisions. This decision was taken by Advocate Ivy Tenga, the DPP in Limpopo division. And I understand that there are representations that are being made, so the matter is still an open matter. The issue of the financial and operational independence, I think you raise a very important issue, and I needed to be clear about this so that it's clearly understood. And then, as you said, if the committees will assist us moving forward, it's important that this distinction is understood. Firstly, the financial and operational independence that we speak about of the NPA does not relate to the president. It relates to the NPA's relationship with the Director General of Justice, who is the accounting officer of the NPA. And that is where we talk about financial and operational independence. And, I've even submitted an affidavit to the Zondo Commission that explains all of this. So that is why it's not an issue relating to the president. It's the NPA's operational and financial matters that the DG of Justice, being the accounting officer, leads to undermining of the NPA leadership, as well as inefficiencies in terms of procurement and various other aspects of our operational inefficiencies. And that is what needs to be dealt with and addressed. And then the issue of the private donor funding model. Let me say, firstly, the NPA does not receive any funding from the private sector at all. The private sector has been involved in supporting various government departments for many, many years in various, in the NPA itself. The Tutuzela care centers has been fully, or well, not fully, substantially supported by the private sector in recent times. 20 years ago, the private sector came on board to assist with the setting up of the specialized commercial crime units, because commercial work was not being expedited. So the private sector support to the NPA is not new, to government is not new. And so we actually currently, the NPA has always been able to secure Section 38 private counsel to deal with our cases. We've been doing that for years, and we continue to do that where we need the additional skills. The engagement with the private sector in the context of the IDAC currently is in the context of the presidential initiative, that where the private sector is supporting government in the context of the Transnet, logistics, ESCOM, and crime and corruption. And so the setting up of earlier I spoke about it, a digital forensic data analytical capability is something that the private sector is supporting the prosecuting authority with. But let me make it clear that these are services that all of law enforcement actually engages with private sector to get these services done. In most of our corruption cases, we hire the chartered accountants in the private sector, various entities. That is part of how we work. We need because we don't have the skills and expertise. The private sector is actually, their services are procured in order to ensure that this work gets done. In the case, in relation to the presidential initiative, they are setting up this capability in order to support the IDAC to do exactly, not the financial investigation part of it, but the data analytical forensic capability. And that, as I said, is because most of it's our evidence is on phones and, laptops and iPads. So that capacity is not an indication of a weakness. It's indication of, in fact, it's in line with international best practices, and our international obligations require us to be engaging with various partners to get the necessary skills and expertise so that we're able to do our work. But importantly, independently, to make sure that the evidence is there. We are not making up any evidence. We are looking at whatever is, properly, the evidence is properly obtained, and then as prosecutors, we objectively look at the cases before we decide whether to prosecute or not. So these are critical skills and capacities that we need in the country. And then the final question, before I hand over to my colleagues, is the issue of the security clearance of one of the deputies of the NPA. Well, let me say firstly that the particular Deputy National Director that you're dealing with is a born and bred South African. He's lived all his life in South Africa. He's got no connections to the UK. He's never lived there. He's got no family there. And he was not working in the NPA until recently, and in citizenship that he acquired in 2018. My understanding is that I think between 40 to 50% of our first cabinet and maybe was people with dual citizenship. And so it does not necessarily mean that you're not loyal to your country. And so we are fully compliant with MIS. And so, this particular deputy does not take prosecutorial decisions. And it's absolutely lawful for South Africans to hold dual citizenship. So I do not see that he's a risk. I have done the declaration that's required, and so we are fully compliant with the MIS standards in that regard. I'm going to hand over to Advocate de Kock and colleagues to deal with other aspects. Thank you, Chair. First, let me ask, Mrs. Soko, and then Advocate Rabajista.
Thank you, NDPP. Thank you, Chair. I'm going to deal with a question in relation to the complex nature of the investigations. Chair, the matters that we deal with, by their nature, they are very complex. We're now talking about, first of all, matters that happened some years back. And true, people went to Zondo and testified. But the testimony that we heard, everyone saying at Zondo, is not the kind of testimony that we can use for the criminal prosecution. So there is a lot of work that we have to do from an investigative point of view to make sure that those matters become prosecution ready. Now, we have to deal with issues relating to a huge number of data. Petabytes of data, terabytes of data in most of these investigations. You find that our dockets, they cover hundreds of ACLIVA files, thousands of statements in relation to these investigations. You also have a situation where in most of these investigations, there are transactions that happened outside also of this country. So we have to embark on MLA processes with foreign jurisdictions to get information to assist in relation to these investigations. So these are not your normal kind of investigations that you get like they happen only within the country and all the evidence is within the country. So that is some of the challenges that faces us when we conduct this kind of investigations. And a part of the problem also is that some of the capabilities, like we spoke about the digital forensic, the data analysis, we do not have those capabilities within the NPA. So we have to outsource also those capabilities from private sector players to assist us in those investigations. So these are some of the issues that make these investigations take longer than any other ordinary investigation. Thank you.